effort, Mr. Chairman.
Thank you, gentlemen, for yielding. We've heard a lot of discussion today about Ms. Lerner, and I was listening to Mr. Duncan, who I have a tremendous amount of respect for, and as he talked about the whole idea of someone coming in and making a statement and then asserting their rights under the Fifth Amendment. And, I don't think the founding fathers were about the business of a gotcha type of situation. Rights are very special things. They are, as the chairman said, as he began this hearing, I have a respect for him for saying that this situation should not be taken lightly. And I think that, every time I sit in hearings like this, I have to try to make sure that I get past politics and try to figure out, number one, what is right. And I also think about how we will be viewed. There's been a lot of discussion about all the wrong that Ms. Lerner did, the alleged wrong. And I want to be clear, I really would love to hear her testimony. I would love to hear even some of the answers to things that my good friend Mr. Gowdy presented, because they are legitimate questions. They are questions that will allow this committee to do its work most effectively and efficiently. And I think we all deserve to hear those answers. But there comes a point in time when certain things trump other things. And in this instance, the idea that there are rights that one had to assert not to incriminate herself, I think we have to deal with that first. As I said in my opening statement, it's not about this is bigger than us. It's bigger than this moment. It's bigger than Ms. Lerner. It's about generations yet unborn. And I think it was Mr. Connolly, who asked the question, and although people laughed, it was a serious question. When people come before this committee in the future, will we have to read them their rights? Will we have to say to them, give them more like a Miranda warning type right statement? Will we have to tell them that any syllable that's said may very well be used against them? And I think we really have to be very, very careful in the precedent that we're setting. There will be disagreements with regard to the law. After practicing over 20 years, I had a lot of disagreements with lawyers. I remember in law school, we would argue cases in moot court. One person would look at the same facts and have one opinion, somebody else will look at it and have another. But no matter how you look at the facts, the thing that must prevail are the rights of the American people. That's what this is all about. The rights. And so, as Mr. Duncan spoke, I thought about some of the criminals that I've come across. I mean, some rough people. But they still had rights because they were still Americans. And that's the wonderful thing about this country. And I will close with this and remind all of us that this is our watch. We are on the earth today, and I think it is so important that we pass on a democracy to our children and our children's children that's strong, is just as strong as the one that existed the day we were born. But that I yield back. I thank the gentleman. We now go to the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. When Mr. Cummings talks about rights, Mr. Chairman, I'll listen. I'll listen because he was a very, very good attorney. I'll listen because I'm familiar with his personal narrative. And while he was talking, I scribbled down, of course he's right. You have a right to remain silent. You also have a right to confront your witnesses. That right is in the exact same document that the right to remain silent is in. You have a right to cross-examine witnesses, Mr. Chairman, and I think it's important for us to spend just a minute on why our framers thought it was so important that you be able to confront and cross-examine witnesses, because it is the single best way to elicit the truth. Yes, you have a right to remain silent. You also have a right to a jury trial, but it's waived every day across this country. When you plead guilty, that is a waiver of your right to a jury trial. You have a right to counsel in felony cases. People waive it all the time and make the mistake of representing themselves. So when we're going to talk about rights, let's talk about all the rights, including the right to confront witnesses and cross-examine witnesses, Mr. Chairman. And it's important that we understand why we were given those rights. Ms. Lerner is an attorney. She's not like the folks that Mr. Cummings represented or the folks that I prosecuted. She's an attorney, and she had an attorney sitting behind her. And some of my colleagues on the other side this morning, Mr. Chairman, and you heard them, they said we need another hearing where we can bring in experts. Well, let me take out all the drama from what that hearing would be like. We would pick 3 that said she waived, and they would pick 1 that said she didn't. Okay? I hate to do a spoiler, but that's the way that hearing would go. We would find 3 that said she waived, and you would find 1 that said she didn't. So we'd be right back where we are now, which is us having to make the decision. Or, Mr. Chairman, we can go to the language of the Supreme Court, which is kind of the ultimate expert. I would argue it is well established that a witness in a single proceeding may not testify voluntarily about a subject and then invoke the privilege against self-incrimination when questioned about the details. And the Supreme Court continued, in such a case, the privilege is waived for the matters to which the witness testifies, and the scope of the waiver is determined by the scope of the relevant cross-examination. What that says, Mr. Chairman, is you do have a right to remain silent. But when you talk, not some talismanic recitation of words which they're saying you should have done, some rote liturgy that you have to repeat to a lawyer who knows her Fifth Amendment right as well as you do. But when you waive by testifying, you subject yourself to cross-examination. And that is true for every client that Mr. Cummings had. It is true for every sexual assault victim that I had to call as a witness. They couldn't give their version of what happened and then not stand for cross-examination. That's not the way the system is set up. And it's not set up that way because the purpose is to elicit the truth. So, Mr. Chairman, I'm going to simply ask this. This is what she said when she came before our committee. 17 separate factual assertions. If this is not testimony, can someone on the other side of the aisle please tell me what is? Does it have to be 20 factual assertions? 25? What constitutes testimony to you? If what she said and the pervasiveness of her testimony, 17 separate factual assertions, if that is not testimony, then tell me what is. And if that's not waiver, then tell me what is. Mr. Chairman, there's been a lot of conversations about rights. Most of the conversations have been about Ms. Lerner's rights. But that same document gives you the right to free speech and the right to petition your government for redress. And while Ms. Lerner may have waived her right, our fellow citizens did not. And the only way we're going to find out what happened is if she answers our questions. Not just says, I did nothing wrong, but answer the questions that all of you agree are legitimate questions. If this isn't waiver, tell me what is. And if that wasn't testimony, then please explain to me